Case is State versus John Wessels. If counsel could please step forward. May we please have appearances of counsel? Good morning, counsel. Mr. McMahon.
If it pleases this court, I would like to first address the issue of retroactivity that this court pointed us to when it asked us or ordered us back for re-argument. With regard to that issue, this is clear. Schatzner must be given retroactive application under federal jurisprudence. There really is no argument against it. Whether we start with Griffin versus Kentucky and work backwards, or whether we start with Johnson versus New Jersey, which gave retroactive application of Miranda limited to people in Mr. Wessels' position who were pending trial. No matter how we go, it is given retroactive application. Edwards itself was given retroactive application, pipeline retroactivity, to those cases that were not yet final in Shea versus Louisiana.
You're not going to come back before us in a case where it's 13 days and argue differently, are you? I just want to make certain about that.
Well, Justice Alvin, I do want to address this issue because you asked me to address it, but I do.
Because you know what's good for the goose is good for the gander if you're making this argument. That if you're arguing it's retroactive for less than 12 days, then it's retroactive for when the police approach more than 12 days. 14 days, I'm sorry, 14 days.
Well, clearly what Schatzner said was if it, and I really do get caught up in the 14 days. I believe, I would like to say it's after 14 days, but I think the 14th day, perhaps the police can come up, but we don't need to address that right now. But with regard to Schatzner, what Justice Scalia said was if it's beyond that 14-day line, well, then you're still free to determine whether the statement was, with the waiver of counsel or whatever, was voluntary.
But the presumption of involuntariness disappears.
Yes, but Justice Alvin, if I could, I should have added, I wanted to address retroactivity first because the court asked me to. But I am still here, and even though Mr. Wessels would be taken care of, so to speak, by just applying Schatzner retroactively, I would like to advocate before this court that this court give greater protections to defendants in John Wessels' position than the U.S. Supreme Court gave in Schatzner. And I do have an argument that I would like to make to this court on that issue. But if you wish me to further address retroactivity, I will. I think it's pretty clear. Then if I move on to why I believe this court should give greater protections, I recall being before you, it'll be a while ago now, when we talked about this before we had the Schatzner opinion. And I talked about asking this court to use our state jurisprudence to give greater rights to defendants in John Wessels' position. Now, I'm here today with the Schatzner case present, and I would like to still make my argument and perhaps modify it slightly. Because what I would ask this court in granting greater rights under our state jurisprudence is let's leave out those troublesome areas of extending Edwards when there's a break in custody. And when I say those troublesome areas, Roberson and Vinnick, if we leave those out, it makes sense, first of all. So Roberson is a situation where, as we know, the defendant is in custody. He's questioned about offense A. And now, time he still remains in custody, police come back, maybe different police officers, or maybe the same police officers, and they want to ask him about offense B. And Roberson says you can't do that. That initial request for counsel bars that. As we know from the Schatzner opinion and from the arguments in Schatzner and the briefs in Schatzner, extending that after a break in custody comes up with some really ludicrous possibilities where we talk about years later someone's arrested on a new offense, now they're back in custody, and that's unworkable. So let's take that out of the equation. And same with Minnick, where we're talking about a situation with different, basically, if I call it, different law enforcement officers who are coming back, completely unrelated, no knowledge, and they're coming to ask questions in that situation.
Are you giving a hypothetical, or are you talking about
I'm
Wessels?
sorry. I knew I was making a mistake when I was. Apologize to you, Your Honor.
I'm trying to follow the stream of your argument.
Yes.
Are you suggesting to us, under our state law, with respect to the presumption of involuntariness, that we not be guided by a 14-day limit? Is that what you're arguing? I'm trying to follow you.
I'll just succinct. I should have started by saying this. I apologize. What I'm saying is that when we have a situation like John Wessels, where we're talking about a break in custody, and let's assume it exceeds 14 days at this point in time, a break in custody exceeding the time limit in Schatzner, where defendant is either rearrested or put back in a custodial setting for the same offense, and where he's reinterrogated by the same officers, by the same law enforcement body, or by another body acting in concert with them, such as the police and prosecutor's office on the same case, that in that situation, this court should not recognize a break in custody exception to Edwards. And it makes logical sense. First of all, as I argued before you the first time, a break in custody does nothing to counter-effect the coercive environment that the defendant finds himself back in. That is, when he was in custody the first time, he was removed from his family, he didn't have control of his environment. All of those same factors, they're still there the second time.
Mr. McMahon, can I interrupt you? The questioning in this case took place 9 days after the second round of questioning.
Yes.
And your argument is Schatzer applies, is retroactive, and therefore you win. So what theory would you advance that says we should go beyond the facts of this case and issue a larger pronouncement?
Your Honor, I believe that this case gives the court that opportunity. Obviously, this court does not have to do anything more than what you just said. If you wish me to stop, I will stop. I will.
It seems like you're arguing a different case, and there may well come a day for it.
I'm arguing for a greater, a more encompassing ruling that would go beyond Mr. Wessels' situation. Yes, I am. So
we have your argument.
Does it make a difference in terms of your retroactivity position that Justice Scalia makes clear that he is not resting his decision on constitutional grounds?
Your Honor, I saw that the State cited for that in their brief, and that, quite frankly, I took a long time to try and understand what they were saying. Justice Scalia is saying in that opinion that Edwards itself is not a constitutional mandate.
Correct.
That the protections in Edwards. Meaning if it was a constitutional mandate, we couldn't tinker with it. We couldn't change it. It's required. It would be like looking at the Fifth Amendment itself. And the Fifth Amendment, as it reads, no person shall be compelled in any criminal case to be a witness against himself. That's a constitutional mandate. The court can't change that language. What Edwards is a prophylactic rule.
Correct.
That's designed to give effect to that constitutional right. So
Is the
is
14 days a constitutional mandate?
no. It's another. Well, it's not. No. If you use that language as Justice Scalia utilized it, it's not.
Okay,
it's
so
another prophylactic.
How does that
rule.
relate to retroactivity?
Yeah, and take assume that Schatzer isn't retroactive, then the existing law is Edwards, correct? So how would that change how would that change the outcome?
Okay. First of all, if I could address the retroactivity in that context, it doesn't change. Edwards, all Schatzner is doing is basically now defining the outer limits of Edwards, where we didn't have any outer limits before by the Supreme Court. Now we have a defined outer limits. So it is just the same thing, a prophylactic rule designed to give effect to the constitutional right. Edwards was given retroactive application.
Schatzer's limiting Edwards. So if you don't apply Schatzer retroactively, then you have Edwards in all its full glory, correct?
I thought the same thing, Justice Albin, because here in New Jersey, clearly, Schatzner is limiting Edwards. We never recognized the break-in custody exception to Edwards. But as we know from our last argument, there are many jurisdictions that had break-in custody exceptions that lasted hours.
That's the reason why I'm asking. If we said, okay, we're not going to apply Schatzer retroactively, what law are we applying? We're applying Edwards, which is the reigning law before Schatzer, correct?
Right.
How would that change the outcome?
Well, if you applied Edwards and you said that there was no break-in custody exception to Edwards, then Mr. Wessels still prevails and everyone else prevails as well. My only argument, which I will go back into, was to remove from that analysis those troublesome areas.
It seems to me that the state, in the end, benefits from a retroactive application of Schatzer because it benefits by a 14-day limitation, and therefore in all of those cases where the questioning occurs 15 days and more, the presumption of involuntariness no longer exists.
I agree with you. That is why, perhaps inartfully, I was making my argument why this Court should give greater protections than Schatzner, and perhaps the appropriate way to do it is to make it clear that New Jersey doesn't recognize a break-in custody exception to Edwards. I just wanted to address those areas that become more troublesome. But I'll leave that. I should mention to the Court two additional cases, which I'm sure the Court's aware of, that obviously were decided after we filed our briefs originally in this matter on this. One is Lee Andrew Coleman Fuller versus State of Maryland. That's at 192 Maryland. It's Appellate Division Opinion 577. That was decided May 27th of 2010. And that applied Schatzer retroactively to a 7-day break in custody. Also, I'll just mention United States versus Linder. That's a U.S. District Court case from the from the District of South Dakota. 759 F sub 2nd 1133, a September 2nd 2010 opinion of it's a district court case, but it also applied Schatzner retroactively to a 3-day break in custody.
These cases don't get into detailed analysis of the retroactivity question.
They
Is that fair?
absolutely do not. And it's interesting, Justice Rabner, that you mentioned that, because when I was looking for, through my research, cases that dealt with pipeline retroactivity of say, Roberson, I wasn't even able to find that. I was able to find cases that dealt with why Roberson wasn't applied to collaterally, but all the cases made it clear, of course, if this was on direct appeal, it would have applied retroactively. So I think that they don't address the issue because it wasn't raised because the federal jurisprudence is that clear.
Thank you.
Thank you.
Ms. Sims.
Good morning, Your Honors. May it please the Court. Defendant Wessels, unlike Defendant Schatzer, had a true break in custody. Wessels was released from confinement for 9 days between his first and second encounters with law enforcement, and his release was non-pretextual. These facts dissipate the pressures of a custodial interrogation. Here, the Appellate Division properly held, after an exhaustive review of pertinent case law, both federal and state, and without the benefit of Maryland v. Schatzer, that the 9-day break in custody that defendant enjoyed, free from any restraints whatsoever, was sufficient to break the Edwards rule. Subsequent to this Court initially hearing oral arguments in this matter, the United States Supreme Court decided Schatzer. The Court held, under the facts of that case, where the defendant was in continuous custody for 2.5 years, that 1, the Edwards rule does not apply if a break in custody lasting 14 days has occurred, and 2, the defendant's return to the general prison population after he had invoked his right to counsel during custodial interrogation regarding allegations of criminal conduct separate from the conduct underlying his convictions constituted a break in custody. Now, the state recognizes that this court may accord broader rights to an individual than what is afforded under the federal system. Nevertheless, the state makes the following arguments. It is clear that Schatzer places limits on the reach of Edwards. The Edwards prohibition does not apply to questioning initiated after a suspect has been released from custody for some time. Schatzer also confirms what had been universally acknowledged, that once a break in custody occurs, it has to be of sufficient duration to dissipate the effects of Edwards' protection. According to the court, 14 days provide sufficient time for the suspect to get reacclimated to his normal life, to consult with friends and counsel, and to shake off any residual coercive effects of his prior custody. The 14-day rule announced in Schatzer is not a rule of federal constitutional mandate that must be applied to the instant matter. Rather, it is a judicially prescribed prophylaxis that rests not on precedent, but on the court's view that law enforcement needs to know with certainty and beforehand when renewed interrogation is lawful. According to Schatzer, it should be given prospective application because a new rule of law has been announced. Never before has the United States Supreme Court decided to specify a period of time as the logical endpoint of the Edwards disability, and certainly not a 14-day period of time. The time period was unanticipated and unprecedented. The federal question before this court is not whether the 14-day rule is new, because it is. Rather, the question is whether the 14-day period is a constitutional mandate. If, as Schatzer teaches, application of Edwards is not constitutionally impelled following a break in custody, then the same must be said of the 14-day rule, which was selected as a matter of administrative convenience to guide law enforcement as to when renewed interrogation is lawful. The time period is not of constitutional making, and compliance with the 14-day rule would not necessarily end the underlying constitutional inquiry. A defendant who experiences a 14-day break in custody is still free to claim that his Miranda waiver was involuntary. The conclusion that the 14-day period does not automatically bar the confession in this case also follows under state principles of retroactivity. The 14-day period, if adopted by this court, is sufficiently novel and unanticipated to qualify as a new rule. The so-called 3 Nash factors must be considered. 1, the purpose of the rule and whether it would be furthered by a retroactive application. 2, the degree of reliance placed on the old rule by those who administered it. And 3, the effect a retroactive application would have on the administration of justice. Expansion of the immunity does not further state common law rights against self-incrimination, and there is little to recommend it as sound judicial policy. The same conclusion applies to the 14-day rule. A waiver executed by a suspect after a 14-day break may be entirely voluntary, but it may also be involuntary. The length of the custodial break does not define the fairness with which a defendant is treated. The 14-day rule does not solve the dilemma to authorities who are unaware that their suspect recently made an Edwards request in another case and was then released without formal charges. In Wessels, the break was 9 days, clearly less than the 14 days Schatzer requires. But this court must look to other factors which support voluntariness and employ the totality of the circumstances test adopted by the appellate division. In sum, the 9-day break in custody that Wessels enjoyed, free from any restraints whatsoever, was of sufficient duration to break the Edwards rule. Further, the 14-day rule announced in Schatzer is not a constitutional mandate that should be applied to this case because it is a new rule of law sufficiently novel and unanticipated. It should be given prospective application.
Are you done with your opening statement, counsel?
Yes, Your Honor.
Counsel, are you arguing that Schatzer was not a break-in custody case?
Schatzer, under the facts of that case, was a break-in custody case. Yes, Your Honor. In our case, we're arguing, in Wessels, we're saying that we're talking about a defendant who was not in continuous custody while the defendant in Schatzer was. Well, although there, the court decided that release in the general population.
Scalia was speaking in Schatzer of the cases of breaking custody.
Yes, Your Honor.
Okay. He wasn't applying that just to prison population cases. Would you agree?
I agree, Your Honor.
Okay. So therefore, when we're looking at the principle of Schatzer, we're dealing with break-in custody cases in general, correct?
Correct, Your Honor.
Would you agree that Justice Scalia, by creating this 14-day rule, was intending to assist law enforcement, not to hurt law enforcement?
Absolutely. He said that, the Justice actually said that in the opinion, that the 14-day rule is actually a guide to law enforcement because they need to know beforehand when renewed interrogation is lawful.
And it ends the presumption of involuntariness after 14 days, correct?
Correct, Your Honor.
So my question to you is, if we didn't apply Schatzer retroactively, we would have to fall back on Edwards, which had a presumption of involuntariness without any end.
Exactly, Your Honor.
Aren't you benefited in the long run across the wide spectrum of cases with the retroactive application of Schatzer, because in all cases in which there was a reinterrogation, 15 days plus, the presumption of involuntariness disappears?
Except, Your Honor, when you're talking about the Edwards, once the defendant invokes that right to counsel, questioning must stop. And that was what was done in this case. Now, at some point, authorities, the court, will have to grapple with, does this continue forever? In Schatzer, again, the 14-day was as a guide. So over 14 days, then the confession is deemed voluntary. And in fact, Judge Fulilov never referred to Schatzer in the remand decision that he submitted to the court, even though Schatzer was available at that time. And Judge Fulilov, even though in this case, in Wessels, the break was 9 days, he actually found that the September 12th interrogation was voluntary. So I think, in a way, that goes to that answers Your Honor's question, in that if Schatzer were to be applied retroactively, then under Wessels, the interrogation at the September 12th would actually still come in based on the findings of Judge Fullerov.
So you're saying that leaving aside Schatzer, that the presumption of involuntariness in this case on these facts is overcome?
Exactly, Your Honor. And in fact, in I believe it was the Linder case that Mr. McMahon mentioned, where there was a very short period of time. It applied Schatzer, by the way. It was a 3-day break, and the courts in the Linder case and even the Coleman-Fuller case, or maybe it's Fuller-Coleman, but Coleman-Fuller case also applied Schatzer, but the court did not address the issue of retroactivity. In any event, the state's position before this court at this time is that Schatzer should be given prospective application based on state principles of retroactivity.
Judge Fullerov suppressed the statement.
Judge Fullerov suppressed the statement of September 12th, but found that it was a voluntary statement.
He found it as voluntary in the sense that the defendant was not being coerced, tortured. They weren't using undue psychological means.
Right. That's correct.
But the principle of law that follows from Edwards is once there's an invocation of right to counsel, it's presumed to be involuntary. No matter, that's just the way it is.
That's correct, Your Honor. When you look at what the findings of Judge Fullerov, and then you take into consideration the test that the appellate division adopted here, the totality of the circumstances test, I would submit to this court that based on the record in this case, the appellate division properly found that the statement of September 12th should be admitted at trial.
On what basis? Because it was 9 days had passed?
Oh, well, the fact that, and in making its decision, as this court knows, the appellate division actually reviewed breaking custody cases, both federal and state, looked at those cases as guidance, the court was very persuaded by Bautista and Storm. Storm, I believe, involved a 2-day break, and Bautista a 6-day break, if I'm not mistaken. But in any event, the totality of the circumstances, the court looked at the length of the, and again, of course, we all know the court did not have the benefit of Schatzer. The length of the break, the fact that the defendant was able to consult with his family, friends, an attorney if he so chose, the fact that there was no police coercion on the September 3rd.
But what weight do we give to Justice Scalia's determination that 14 days would seem to be the minimum amount of time for perhaps a defendant to break off from the original invocation of right to counsel and perhaps have an opportunity to consult friends, attorneys, determine what his fate should be?
The 14-day rule, I think we're also caught up in this, but the 14-day rule does apply. It does apply. But again, the statement, not because it is less than 14 days means that it automatically is excluded. I think the fact finder has to make very fact-specific, and to use the Justice Scalia's word, make a fact-intensive inquiry.
You're arguing for a totality of the circumstances analysis here, right? Whether it's 15 days or 9 days or 3 days.
Right.
You're not giving much weight to Schatzer in that analysis because the totality of the circumstances analysis applied before Schatzer, and you're suggesting that we look at that and not focus on the 14 days here.
That's a difficult one. I don't want to stand before this court and argue that a prophylaxis rule by the United States Supreme Court should not apply to this case.
I wouldn't want to make that argument either. It's a tough argument.
Pardon?
It's a tough argument.
It is a tough argument. Can't make it, really. But what I am saying that because the United States Supreme Court has come out with this rule as a guide to law enforcement, it should be followed. However, it's the fact that we have this rule does not mean that if the period is less than 14 days, we can't look at other factors in the record which would support voluntariness of a statement.
So give us the facts, all the facts that you have to overcome the presumption. You talked about the break. You talked about the defendant's ability to consult with family, friends, and attorney if he wished. What else?
The fact that on September 3rd, his request for an attorney was honored before it was honored, and he was released. The fact that this defendant went back to his job, lived at home. The fact that he was even given fresh Miranda warnings on the 12th of September. The fact that during those 9 days, he may have considered his predicament because now he has been put on notice that he has come to the attention of the authorities. So during those 9 days, he may have reflected with or without friends or family and decided that it may be in his best interest to cooperate.
These are all the things that Justice Scalia doesn't want us doing, at least going forward, but you want us doing that for the end of cases retroactively. This is the specific fact-intensive analysis that he says he doesn't want, the Supreme Court says it doesn't want occurring. Correct?
If it's over 14 days.
That's right.
But under 14
no,
days.
Under 14 days he doesn't want that. He specifically says that.
But counsel, when you answer that question, consider that Justice Scalia was stating that in the context of someone coming in just for more questioning. In this instance, Mr. Wessels was now arrested for the triple homicide.
That's correct.
He knew he was being charged, and he was getting the Miranda warnings in the context of being on notice that he is now the charged defendant for these crimes. Do you think that Justice Scalia's desire to help law enforcement have a bright line rule meant to be applied in the context of their ability to talk to a defendant who is now arrested on a crime, as opposed to someone who is simply being talked to by the police in the context of an ongoing investigation?
Under that scenario, Your Honor, just taking Schatzer as a whole, again, it was just offered as a guide to law enforcement. The 14-day rule, I mean, just the court came up with 14 days, and in Justice...
And they came up with 14 days in the context of somebody who 6 years after the initial inquiry is now going to be just talked to again because a detective was reopening a sexual assault or abuse investigation. Very different situation than someone who is now brought in under arrest and charged with a triple homicide.
That is true, Your Honor, but my response to that is, again, this 14-day rule it's just a guide.
You can arrest somebody less than 14 days, but you can't talk to them.
You can't talk to them if you give them the proper warnings, right, and they waive.
And they waive them, and then, but what? It's still presumptively involuntary because Justice Scalia has said we want a bright line 14-day rule.
No, Your Honor, I don't believe it necessarily per se.
You would argue in that case that the presumption is also overcome in such a case?
Yes, Your Honor.
Is there anything else you'd like to add to your argument, Ms. Sims?
No, Your Honor. I think the State's position regarding the retroactivity issue that the Court was interested in, I believe that's specifically stated in our brief. The only other thing I would add is that State principles of retroactivity should actually govern this Court's decision on that particular issue. Unless the Court has any other questions.
Thank you. Ms. Thomas.
Good morning, Your Honors. I'd like to lay out first that I believe that Schatzer actually imposes two rules, and sort of we need to look at them separately. First, it does give credence to those lower courts which it said, the lower courts that have uniformly held that the Edwards presumption ends at a break in custody. So Schatzer essentially accepted that authority. It said that a break in custody means something, and it had hinted at such in several of the cases beforehand, especially in McNeil, where it said, assuming there has been no break in custody. So this break in custody is not the first time that the Supreme Court has held that a break in custody may mean something. It just sort of clarified that. Now, we know that a clarification in prior law should be applied retroactively. And so the actual break in custody, that it means something, that after a break in custody of sufficient duration, the Edwards presumption ends. That should be applied retroactively. Then the court gave a guideline. It gave a rule of 14 days. And it said at 14 days, we know, and we will give guidance to law enforcement, that they do not have to worry about Edwards. We don't have to do an Edwards analysis. We don't have to decide whether the defendant did previously invoke. So now we have a clear-cut rule that law enforcement can follow in the future, and which is a good thing for law enforcement. They now know that they don't have to worry about it. But never has the Supreme Court, this court, or any other court given any sort of time period for that. There's never been a suggestion of a time period, or especially not 14 days. So when law enforcement, especially in this state, were reinterrogating a defendant or suspect after a break in custody, which they deemed to be of sufficient duration, they believed that they could go talk to that person again. And so the 14 days cannot be held retroactive because the law enforcement in this case had no benefit of knowing that that 14-day rule was going to come down in Schatzer. So when we look at the elements of reliance that the retroactivity analysis must incorporate, the law enforcement in this case, in Wessels' case, they relied on the law that was in the books at the time, and they had no idea that by interrogating him in 9 days as opposed to 14 days would have any implication or any relevance on the ability to admit that confession at a potential later trial.
Yeah, but they knew Edwards, and this is acknowledged by Justice Scalia, had a presumption of involuntariness. Would you agree with that?
Absolutely, yes. But then Edwards was clarified later on. So we have Edwards, yes, which laid out the original principle that said that if an accused does invoke, then there can be no reinterrogation. And it did talk about being in custody, the effects of prolonged custody, and that was sort of continued in Minnick and continued in...
But Scalia also talked about the presumption, the Edwards presumption, even in Schatzer. He considered it a presumption. He uses that language.
Oh, I don't disagree that it's a presumption of involuntariness.
I saw it trying to assist law enforcement by give it a bright line. The presumption will exist up to 14 days, and it will disappear after 14 days. But within those 14 days, it's there.
Sorry, excuse me. And I think I disagree slightly with that, with Your Honor's take on Schatzer. It does lay out a rule as to what happens after 14 days. We know that. It says specifically, after 14 days, courts no longer have to engage in the Edwards analysis, and Edwards no longer applies. But it also says that a break in custody or a break in custody of sufficient duration to end the lingering effects of Miranda custody ends the Edwards presumption. It doesn't say specifically that the 14-day rule is a per se rule. We know that the U.S. Supreme Court knows how to make a per se rule. It would have said that the presumption of Edwards will always continue up until 14 days, and any confession before that is automatically inadmissible. They've said that before in other cases, but they didn't say it here. And so therefore, we have to treat that pre-14 days, that the presumption will continue up until a sufficient duration to dissipate those lingering effects of Miranda custody. And the totality of the circumstances have to be used to look at that pre-14-day period. I will say that after Schatzer, if the law enforcement interrogate a suspect before 14 days, that is a factor that will weigh against the state, because now we have this 14-day rule. And I know I would, and I think any reasonable prosecutor would provide guidance to a law enforcement officer that would come and ask, can I go back and it's been 12 days, excuse me.
What good is a 14-day rule if it's not 14 days? in neon lights giving a warning to law enforcement, do not reinterrogate people who have invoked their Mirandas within 14 days.
I look at it more as a guideline. It's a set period in time where law enforcement will know.
Where does he say that? I'm looking at the opinion where he's maybe it's not crystal clear. I'll try to get the site to you where I'm looking at it. It's from like U.S. 130 U.S. between 1223 1224, where he's saying now in cases where there's an alleged break in custody, they, referring to the police, simply have to repeat the inquiry for the time between the initial invocation and reinterrogation. In most cases, that determination will be easy, and when it is determined that the defendant pleading Edwards has been out of custody for 2 weeks before the contested interrogation, the court is spared the fact-intensive inquiry into whether he ever anywhere asserted his Miranda right to counsel.
My interpretation of that language is sort of how I started, that language sort of separates the opinion into two rules. First, the court has to determine whether there's a break in custody. And the court determined that in Schatzer there was, and we know that in Wessels there was because he was released. So the Supreme Court is essentially saying that break in custody means something, and this court has to determine if there is a break in custody, whether there was an invocation. But then it doesn't say, at least under my interpretation, it does not say what happens before 14 days. It only says that after 14 days.
So
well, how is it spared the fact-intensive inquiry then?
And what sort of bright-line rules is he creating then?
Sorry, excuse me.
Because if he's trying to give the police clear signals as what to do, you're saying the 14 days really isn't the 14 days. You'll know that 14 days afterwards, but take your chances within the 14 days, and maybe some court will find that the presumption of involuntariness wasn't overcome.
I think in the future, I think it's fair to say that this situation is not going to come up because now we have that 14-day rule, and it is, I believe that officers are...
You're arguing it's not a 14-day rule.
It's a 14-day, it's an after 14, I know a rule, I guess I tried to come up with another word other than rule, but it's like an after 14-day rule. He's telling us what happens after 14 days, and that's taking every case that happens after 14 days, including Schatzer and many other cases that have a break in custody more than 14 days. And they said that's when those coercive effects automatically are gone. We know in most cases those will be gone. And it can't be a per se rule because the court said in a footnote that the defendant still has, even after those 14 days, the opportunity to prove that the statement is still involuntary. So it's not automatically the state wins at 14 days. We still have the burden of proof to prove that the statement is voluntary, and the defendant can show factors perhaps that coercion still existed or other sorts of factors that would show as involuntary.
How about just, I'm sorry.
I was just going to say, but then tell me what the court is being spared in terms of fact-intensive inquiry. You can still have a fact-intensive inquiry after 14 days.
No. Well, it could be if the defendant says that it's involuntary, but the court says that. It says in the footnote that that's not and that's exactly the reason why it can't be a per se rule, for lack of a better term. There is a little bit of leeway on each side, but the court has said if you wait 14 days, it will pass constitutional muster under Edwards.
Well, because a person may come forward voluntarily within the 14 days, so we know that it's not a conclusive
Sure,
presumption.
Same as Edwards, sure. Mm-hmm.
But you would agree within the 14 days, the Edwards presumption of involuntariness applies, correct?
Only up until there has been a sufficient until that sufficient duration of time has elapsed under which those lingering effects of Miranda custody.
It's not 14 days?
I don't read the opinion that way.
Because the first paragraph, and Stevens obviously didn't understand at all what Scalia was writing about, because his first paragraph, I'm reading from it,
mm-hmm.
While I agree that the presumption from Edwards is not eternal and does not mandate suppression of Schatzer's statement made after a 2-year break in custody, I do not agree with the Court's newly announced rule that Edwards always ceases to apply when there is a 14-day break in custody.
Exactly. But I think that appropriately states the majority's opinion, because it does always cease to apply. Edwards always ends at 14 days.
So your argument is that for the period prior to that 14-day mark, the only impact of Schatzer is that it clarified that a break in custody is enough to overcome the presumption or enough to negate the presumption?
Well, the break in custody, I would say, it's not sort of a magic period. It has to be a break in custody of sufficient duration, and the court told us that. However, I don't think it's just that the under 14 days doesn't mean anything. Now, officers have a clear rule, and it's similar to the rule that they laid out in McLaughlin, which they referred to in the opinion, which is that a probable cause determination must be determined within 48 hours. But there's a little leeway before and after, and the burden sort of shifts. Here, the burden never shifts, of course. But before 14 days, now the law enforcement and courts have guidance that 14 days, if it's after that, then you're spared this Edwards analysis.
Well, what happens before that? Is your argument that there is no presumption during that 14-day period if there is a sufficient break in custody? There's no presumption at all? Or is your argument, as I believe the prosecutor's argument is, that the presumption exists but can be overcome through a factual determination?
I'd say it's a little bit of both, if I may. It's that the presumption continues up until the burden has been overcome using the totality of the circumstances. And when the burden is overcome, that's when the presumption ends.
So aren't you really arguing that there's a presumption, but it can be overcome through normal shifting in the burden in a presumption situation?
Certainly, yes, definitely. There have to be the state of, and essentially it's a voluntariness argument. If the state has proven that it was voluntary, that sort of works to show that the presumption has been overcome. And when the presumption has overcome, when the state has shown that, and that the coercive effects are no longer there, that's when the Edwards presumption ends. And it can apply, and it could end at some point within those 14 days, but we know it definitely ends at 14 days.
But Scalia, he's definitely talking about a presumption, but he seems to be talking about it as being very difficult to overcome. Quoting from his opinion again, we think it appropriate to specify a period of time to avoid the consequence that continuation of the Edwards presumption will not reach the correct result most of the time. He goes on, it seems to us that period is 14 days. That provides plenty of time for the suspect to get reacclimated to his normal life, to consult with friends and counsel, and to shake off any residual coercive effects of his prior custody.
I don't disagree that it's a burden that's going to be difficult to overcome post-Schatzer for confessions that occur after Schatzer, after it was announced, because now we have the 14-day guideline. So anything under 14 days is going to be...
But you're suggesting that Schatzer was making the Edwards presumption greater within 14 days than it previously existed?
Oh, no. I mean, I think it's when a defendant is in custody or a suspect is in custody, I think it's fair to say it's an irrebuttable presumption that Edwards applies unless and until the defendant has reinitiated interrogation. So we know that it's a hard burden to overcome in custody. I think, so now we have a similarly high burden, but not a burden that is not able to be overcome within that 14 days. And again, this argument only applies if this court deems that Schatzer is retroactive, which we don't believe it is. And I think that if you look at the language of Schatzer and what Justice Scalia said in Schatzer expressly, it gives us guidance that it should not be applied retroactively. First, it calls it it's not a constitutional mandate. And also it says, he uses words like now, and that officers need to know with certainty and beforehand that 14 days will end the Edwards presumption. So, and while Miranda and Edwards were both applied retroactively to cases that were in the pipeline, so to speak, the 14-day rule is a clear break with prior precedent. There has never been any sort of insinuation that this 14 days could be a magic number.
Don't you think not applying it retroactively, I see could be hurtful to the state, because if Schatzer doesn't apply, then the presumption of involuntariness is maybe not eternal, as Justice Stevens was willing to concede, but greater than 14 days. Because it's not until Schatzer that Scalia cuts it off. So it won't be going on for 30 days and 60 days or 90 days or 6 months. He's doing you a favor.
Well, I think, though, it's difficult for me to stand up here and say that it should be applied retroactively, because what about all the law enforcement that relied on all the case law that had existed previous to that said that they could reinterrogate after a sufficient break in custody has existed? So they didn't know that 14 days would be a magic number, and so we could lose all those confessions, even though under the totality of the circumstances there was no coercion.
And you'll win all of them 15 days plus.
I'm sorry, excuse me?
Then you'll win, and maybe and if it's not retroactive, maybe you'll lose as a result of not applying Schatzer retroactively those confessions 18 days out, 30 days out, because under Edwards, the presumption of involuntariness goes on.
My reading of Edwards, though, is that the presumption of involuntariness continues when the suspect is in custody. It's different if there's a break, and we're talking about break in custody cases, of course, here. So it would be, we're looking at the cases that are sort of in the pipeline or confessions that occurred pre-Schatzer where there was a break in custody and then the police went back and reinterrogated, under which they thought that they were doing so after a sufficient duration, which sort of cured those lingering effects of Miranda custody. And under all the case law, they were acting appropriately and in reliance on that case law. And that's and so they were acting in good faith. And to apply a 14-day rule, while the burden could still be overcome, again, that burden is going to be a difficult one to overcome pre-14 days.
Can you address the language in Griffith that says a new rule for the conduct of criminal prosecutions is to be applied retroactively to all cases, state or federal, pending on direct review or not yet final?
Yes. The 14 days is, of course, Griffith and even Johnson and other cases that were interpreting some of these Fifth Amendment cases or Fourth Amendment cases were actually looking, of course, at we know that Miranda and Edwards has been held to not be a constitutional mandate. It's a prophylactic rule. And the court said so also that this 14-day rule is not a constitutional mandate. It's a prophylactic rule. But I would suggest that those cases are different from the 14-day rule that was espoused in Schatzer, because those cases were simply a continuation of previous law. It was a clarification. And in Shea and in Stooms, when in the two cases that interpreted the retroactivity of Edwards, they said that Edwards was not a clear break in prior jurisprudence.
In response to the Chief Justice's question, give us examples where pipeline retroactivity hasn't been applied by the United States Supreme Court in situations similar to this. Because Edwards was given pipeline retroactivity. I think, was it Miranda?
Miranda was for trials that have not started, did not start before
Okay, but
Miranda.
Edwards was given pipeline retroactivity, correct?
For the same...
Okay. So give us examples where pipeline retroactivity was not given in situations like this.
A U.S. Supreme Court case is not coming to mind right now, but I would cite to one of this court's cases in Reed. And in Reed was obviously a Fifth Amendment case where this court said that the defendant must be told of a readily available counsel, that the counsel is available, and keeping that from the accused is a violation of his Fifth Amendment. In Abronsky, which is the case that discussed the retroactivity of Reed, it actually said that our holding in Reed will apply to Reed in all cases prospective, and it does not apply pipeline retroactivity. And that's exactly what we would say should be applied here, that Schatzer, it applied in Schatzer, we know that, although the court sort of said before even getting into the 14th.
Do you have any federal, because now you're applying a state rule. Now I'm off the U.S. Supreme Court. Give me any federal authority that would not apply a rule such as this in a pipeline way.
I can't think of one offhand. I would just say that in Johnson, which I believe is there's two Johnsons, and the Johnson, I believe from the 80s, that talked about rules of constitutional mandate should be applied retroactively, and that was the reasoning it gave for applying Edwards and Miranda retroactively. However, it did say there's 3 exceptions to that rule, that constitutional rules should be applied retroactive, and one of them is if there's a clear break in precedent that courts and law enforcement have been relying on and that there's been no indication that it's going to change, that's an exception to that rule. And that's what we have here.
For the complete retroactivity. But one of the rationales for pipeline retroactivity is not to distinguish between, who got to the Supreme Court first, and therefore to create unequal classes of people. So, I mean, that's part of the reason why pipeline retroactivity seems to apply in most of these cases. Would you agree?
I would agree that's one reason, and I believe that was one reason that the court in the U.S. Supreme Court in Shea was relying on. But I believe that there were about 2 other reasons, and I believe it was Justice Harlan's dissent in a case that sort of fleshed these reasons out. And I apologize, I don't remember offhand what the other 2 were, but there are other reasons, and so that can't be the only reason. And here, again, maybe the court did discuss this 14-day rule in Schatzer, but they said they didn't need the 14-day rule to reach their conclusion. They said 2.5 years is enough, but we are going to give guidance to law enforcement. So the fact that they did that in Schatzer could have been decided without even imposing this 14-day rule, to me shows that this should be only applied prospectively, that law enforcement have acted in good faith in approaching a suspect before 14 days, and they shouldn't be sort of held to that same standard when they were acting sort of under the totality of the circumstances analysis to say that there has been a sufficient duration under which the lingering effects of Miranda custody have ended, and they thought they could go back and talk to him. That heavy burden of proving otherwise should not be imposed retroactively. The 14 days should only apply prospectively, and therefore, in Wessels, we should look at the totality of the circumstances to determine whether that break in custody has been of such sufficient duration.
Thank you, counsel.
Mr. Chapman, would the court grant me 1 moment to just address and clarify?
Come to the center, please, Mr. McMahon.
I just want to address the issue that was raised with regard to the idea that this less than 14 days can be rebutted, that this is a presumption that could be rebutted. Schatzner makes it very clear on page 11, 22, and 23, when Justice Scalia is discussing the rationale for setting a time limit, he states, and I quote, "But what about a break that lasts only 1 year or only 1 week? It is impractical to leave the answer to that question for clarification in future case-by-case adjudication. Law enforcement officers need to know with certainty and beforehand when renewed interrogation is lawful." He used that word, lawful. Prior to that time, it is unlawful. That's all I would like to say.
Thank you. Counsel will take the matter under advisement.